Guys, fasten your seatbelts. We're starting off in Florida today with a sovereign person who believes he can gain diplomatic immunity by simply saying UCC and purportedly saying it enough times. Confusion permeates Mr. Fox's whole approach, as he makes no substantive legal arguments while maintaining he is unaware of the claims. The judge isn't in the mood and can see right through it. He strengthens the link and keeps it going with his dry sarcasm and lack of tolerance for games. Hope in one hand, crap in the other, as he says it. This courtroom is serious. You know, buzzwords were what Fox brought with him. Unfortunately, reality is unconcerned. Neither hope nor feigning ignorance can be used as a defense in court.
State your name, sir.
Mr. Fox, for the court charge possession of paraphernalia and a no valid driver's license. You understand the charges?
Understand what you're charged with?
No.
No.
No. She doesn't understand. Allegedly, you had methamphetamine on or about your person, and allegedly, it may have been contained within something that qualifies, aka a clear plastic bag, it qualifies as paraphernalia in the state of Florida. And allegedly, you were operating a motor vehicle without allegedly having a driver's license. You understand that?
I understand the driver's license. Yes, sir.
Okay, well,
Possession.
I didn't say it was yours. Did I say it was yours? I said you've been charged with. Nobody's asking if you did it. I'm just asking if you understand what the charge is. Yes or no?
No, sir.
Okay, then we'll bring you back tomorrow when you understand.
I was hoping I'm not from this state. This county. If I can just resolve everything today.
You got a parole hold. You wouldn't get out anyway.
You got nowhere to go, man. So, do you understand the charges against you or not?
I understand they charging me with it, yes, sir.
That's all you got. See how easy that is? I don't know why do we have to go back and forth
It's
about
not
it?
easy when you're in my shoes, sir.
It's easy it's a yes or no question. Do you understand?
I don't agree to the contract.
Nobody's asking you to admit to anything. I just need to make sure you understand the charge.
I'm a private citizen, sir.
I'm shocked
Under
you're
UCC focus.
Oh, UCC? Oh, I love it. A sovereign.
It's okay, folks. We go on to Washington, where a man with a Sesame Street-like voice says the court has no authority and won't provide his legal name. He attempts to avoid the legal system like it's a gym membership and rambles on about permission. The judge is utterly unfazed, scheduling a hearing without any delay. As he hears something, you can practically hear him searching for phrases on Google in the hopes that it would stick. This is not a defense in court. Sovereign improv theater is what it is. He believes he can win everything by remaining silent. Silence, however, is not a tactic. It's giving up. The bench warrant is also writing itself right now.
Crap in one hand, hope in the other, and see if that helps. Onset at 5,000 on meth, 1,000 paraphernalia, 500 on the driver's license, which oddly enough, the Supreme Court said you do need to drive. Court date is February the 17th at 9 o'clock, but you're not going anywhere because you got that probate or that parole.
Step to your right. So the team.
Mr. Fox, when you sue me, make sure you spell it with two N's. I want to make sure that the AG's office gets involved.
You don't have to worry about that, sir. I'm peaceful.
Sign where the light is for your copy of that.
It's off the 11 o'clock calendar. Mr. Posada, could you please turn on your video for me?
Yeah, hold on one second.
All right, good morning, Mr. Calzada. You're here for arraignment, so could you please tell me your full legal name?
I don't know how that has anything to do with the case. My name.
Well, Mr. Calzada, I need to confirm who you are. So could you please
Here I
tell
am.
me? Well,
I'm here
please tell
physically
me
present, right?
Mr. Calzada, could you please, what is your first name?
My first name? Well, It could be anything, right? I could change my name at will, right?
All right. I'm going to set this matter over for an in-person arraignment, and Mr. Laurie, you'll have law enforcement standing by. All right?
Oh, there you go.
All right. So, Mr. Calzada, I will set this over. You will appear in person at the Bothell Municipal Court for arraignment.
We now speak with Eric Martin, a frequent courtroom guest who views every hearing as a free-for-all for sovereign bullshit. His court-appointed lawyer is at his breaking point and requests to step aside, claiming he has not cooperated. That's code for Eric's incessant tirades on the freedom of movement. Clearly frustrated, the judge makes Eric listen for once by threatening contempt. Although this courtroom deals with law, not fiction, he maintains that his lawyer will not defend his fantastical arguments. Despite his delusions, Eric continues to act as though he is a misunderstood genius. A legal brick wall meets sovereign arrogance. Who do you think loses?
I'm gonna go there today. And you guys were all doing Snohomish County prisoners. Pretty busy, huh? The sheriff even said it's pretty busy. The court has to file a 1099-C. How you file a 1099-C for that bond? You don't need voter approval for that, don't you, those bonds? How much are the bonds?
Mr. Calzada, I'm going to set this to December 31st at 1:30 in the Bothell Municipal Court in person. You will need to be there for arraignment, okay? So I will see you in person at the Bothell Municipal Court at that time, all right?
Looks like there's no free will then.
So
what am I doing here then? Hold on, what am I doing here?
well, right now you are not responding to my questions. So
Well, you're not responding to any of my questions. I don't have a problem of answering any of your questions, but I have a couple questions first. I have to understand too. I don't understand what's going on. I don't know everything.
Judge Slavin is not flinching. He expects at least a modicum of cooperation after ultimately agreeing to assign Eric a new lawyer. But no, Eric returns to his sovereign theatrics right away. At that point, the judge carefully closes it down. The right to silence is yours. Now you may work on that. It's not a discussion club in the courtroom. Monologues on conspiracies are not welcome. Eric attempts to seize the opportunity, but he has already run out of legal options. It's like seeing a kid quarrel with a GPS as this unfolds. It doesn't finish where he expects it to, and you know precisely where it does.
All right, today's the date and time set for a hearing in this matter with regard to a bond violation. This is case 242448 SM. People versus Eric Martin. Everybody hear me?
Yes. Good morning, Judge Donna Silva on behalf of the people, P87439.
Morning, Your Honor. James Kazicki on behalf of Mr. Martin, Your Honor. I have a motion to make.
All right, go ahead.
Your Honor, I'm making a motion to withdraw. I've had contact with Mr. Martin before in other matters, and there's no attorney-client communication in this matter. We're talking about different things, and there's just no way of moving forward that I can adequately represent him, Your Honor. So I'm asking to withdraw.
Your motion to withdraw is granted. Mr. Martin, would you like a different court-appointed attorney?
Yeah, I guess so, since he shows his willingness not to want to do his job and help me out, and he's misstating, making false statements or talking about there's a lack of communication. It certainly ain't on my part. I was pointing out to him relevant defenses. He just don't want to do his job. That's clear what he made of me. So,
Mr. Martin, I have found Mr. Kazicki to be a very competent individual, a very competent attorney in many, many cases. I've seen many trials, hearings, motions, practicing in front of this court. and I found him to be very competent. If you make one more negative comment about him, I'll hold you in contempt of court. I don't do that. We don't act like this isn't the Jerry Springer show. This isn't going to be a bunch of name calling. You're going to knock it off. Knock it off, Mr. Martin. I'm done with everything you keep doing. All your little negative comments, things that you want to say about people, and you think you're the smartest person in the room and that you have some sort of special Juris Doctorate. You don't have the first clue when it comes to things, and you talk about that. And so Mr. Gizicki is saying that he's trying to talk to you about actual legal defenses, and you're trying to bring up some kind of other stuff. And so I'm going to grant his motion. All I asked you was this. I didn't ask you to give me a commentary about Mr. Gizicki or what you think he can do, because I've always seen him do his job every single time he does a file. What I want to know is, do you want another court-appointed attorney, or are you representing yourself? That's it. It's a simple question. Answer simple questions. That's what you needed to start doing, is answering questions.
Yep, one other attorney. But I don't want to say also that if it was recorded, that we would say it would support my allegations.
Boom, time out. Nope, not hearing it. The question is this. Do you want another court-appointed attorney? So you're either going to say yes, court-appointed attorney, or represent yourself. What is your answer here today? Because there's only two possible answers here. You either get another attorney, or you can represent yourself if you like. Or if you want to hire your own attorney, you can do that. So there's three things. Are you going to get one appointed, yourself, or retained? Those are the three possible answer choices. What are you going with?
Yes, another appointed one, but without.
All right, there you go. Don't need any more commentary. Don't need any more commentary about it. You have a right to remain silent. You can exercise that right now. So we're going to appoint another court-appointed attorney to you. And the individual who was here as your attorney during your trial, you seem to get along pretty well with him. You want me to reach out to see if he's available?
I don't know who you're referring to.
The guy who was here at your trial. I don't know his last name.
Oh, he's on the other trial.
Yeah, the other trial, not this case. This is the misdemeanor domestic violence case. I'm talking about your driving on a suspended license case, restricted.
Well, I mean, he did for the most part. I don't want to say for the most part, maybe for the most part, but there's some things he didn't do either. He didn't raise my right to travel defense. So
yes or no? Yes or no? Is he somebody that you think you can get you can communicate well with?
I guess we'll give him a try. I guess. Yeah.
Sure. All right. I'm going to appoint. Reach out and see if we can see if he's available. So let's appoint.
But now, Slade, I have some questions for you before we move forward.
All right. So we're going to set that. We're going to set that for a hearing date, and we'll see you then.
In Michigan, Roosevelt Williams used the most common strategy used by all sovereigns, citing utterly unrelated Supreme Court rulings. He starts with decisions from the Department of Labor that support driving without insurance. The magistrate asks calmly, not flinching, "In what way does that relate to your situation?" Roosevelt becomes motionless. It is comparable to witnessing someone attempt to bluff their way through an exam for which they did not prepare. She analyzes every assertion without much effort. This is more than just a legitimate takeover. It serves as a reminder that preparation is superior to parroting. In a real courtroom, Roosevelt introduced YouTube law. It went just as you would have expected.
Hey, good afternoon. My name is David Heiss. I'm an attorney magistrate. We are scheduled for an informal hearing in two different cases that arise out of one citation. And those two cases are both entitled The People of the City of Battle Creek versus Roosevelt LaShawn Williams. Is that your name, sir?
That is my name.
Basically, what happens is you were issued one citation. It had two violations listed on it, so it became two different cases, one with an A and one with a B at the end. But we have one informal hearing scheduled for both of those cases because they both arise out of the same transaction, so to speak. And I guess, Officer Kellums, is there anything before I begin?
No, sir.
All right. Mr. Williams, you're here because you were issued a citation. And in each of those two cases, so for each of those violations, you have three possible responses to the citation. You can First, admit responsibility, be assessed the fines and costs, and be done with it. You could, as a second option, admit responsibility with an explanation, hoping that the explanation would cause the court to decrease the fines and costs a little bit. Or you can deny responsibility and have your hearing. It's my understanding that as to both cases, you wished to deny responsibility. Is that correct?
That is correct.
Okay. Well, here's how the hearing works. First of all, I guess I should read the citation. In the case ending with the letter A, it's alleged that back on November 19th of 2024, you were over at Fountain Street near Meacham Avenue in the city of Battle Creek, and you were issued a citation for not being able to provide a proof of insurance. This is a civil infraction. If you were found responsible, all other things being equal, the court would assess $125 fines, costs, and fees. It is a 0-point ticket. And in the second case that ends with the letter B, that same date, time, and place, you were issued a citation for having an expired registration plate. That is also a civil infraction. It is also a 0-point civil infraction. If you were found responsible, all other things being equal, the court would assess $110 fines, costs, and fees. So first question, is that the ticket or the two cases that you thought you were appearing about, Mr. Williams?
It is.
Okay, and same question to you, Officer Kellums?
Yes, sir.
Very good. In every civil case, the plaintiff has the burden of proof, and in a case like this, that burden of proof is called by a preponderance of evidence.
Only question I have is, will the laws of the U.S. Supreme Court be applicable? And the federal statutes and definitions of motor vehicle and automobile be applicable in this proceeding?
They are the state of Michigan laws that will be applicable.
Okay. The other question is, are you already not bound by U.S. Supreme Court rulings?
Every court is bound by relevant Supreme Court rulings.
Okay.
The sovereign crescendo is about to begin. Roosevelt asserts that he was traveling rather than driving, and that he is acting under heavenly authority rather than traffic laws. The court gently dismisses each of his ridiculous arguments after allowing him to air them all. She tells him that this has nothing to do with wordplay or theology. It has to do with Michigan law. She never raises her voice. She never falters in her logic. You are not denied the right to travel, she states. You are not allowed to disregard the law. Like a legitimate knockout, it lands when fact and fantasy collide. This is what occurs. The sovereign script just cannot withstand the logic's crossfire.
Very good. All right, Officer Kellums, if you would begin, please.
So on November 19th, 2024, I was on patrol for the Battle Creek Police Department when I observed the vehicle that Mr. Roosevelt was driving. I observed that it had expired tags on the vehicle. I then conducted a traffic stop on Fountain Street near Meacham Ave. Found Mr. Williams to be driving the vehicle, where I issued him the citations. When speaking with Mr. Williams, he could not provide insurance, and his tags were expired.
Okay. Do you happen to know when they expired?
I do not off the top of my head, sir.
Okay. What made you think they were expired? The wrong color and the wrong year on the plate itself, or something?
Yes, sir. Yes, sir.
All right. Did Mr. Williams say anything to you during the stop about having insurance or not having insurance, or anything about the tags on the plates, anything like that?
He informed me that he did not have to have insurance due to that he was traveling, and to drive a vehicle, you don't have to have insurance. Something regarding the Supreme Court. That's about all he said.
Okay. All right. Do you want me to consider anything else at this point, Officer Kellums?
No, sir.
Okay, Mr. Williams, could you hear Officer Kellums' testimony?
Yes, I heard his testimony.
Very good. Thank you for your patience. What do I need to know, sir?
Okay, I did inform Officer Kelly that I am not operating a motor vehicle, but I am operating an automobile. I did inform Officer Kelly of the ruling of Rodriguez v. Ray Donovan, U.S. Department of Labor, 769 Federal 2nd, 1344, where the U.S. Supreme Court's decision has ruled that all codes, rules, and regulations are for government authorities only and not for human creators. In accordance with God laws, all codes, rules, and regulations are unconstitutional and lacking due process.
All right, can I interrupt you just for a second? Are you telling me that a case at 769 Fed Second 1344 indicates that all laws are unconstitutional?
All codes, rules, and regulations. Yes, sir. Rodriguez v. Ray Donovan. And if I'm not mistaken,
and you said that was Department of what?
U.S. Department of Labor.
Okay, U.S. Department of Labor doesn't publish decisions in the Fed Second. Can you tell me a little bit more about the case? What was that issue in the case?
It was regarding what we're discussing here, the requirements of a driver's license and the need when it's required to have one, stating that when you're not operating commerce, to which I informed the officer that I am not operating commerce as stated in USC 18 USCA 31 paragraph A6 states that a motor vehicle, the term of motor vehicle meaning every description of carriage, conveyance, propelled or drawn or mechanical power and used for commercial purposes. This is what Title 18 USCA Section 31A6 states or defines as a motor vehicle, to which I am not operating in commerce.
We're going to make a crash landing as we close. Under duress, Roosevelt is unable to provide an explanation for any of the final Hail Marys he tosses, citing Shuttlesworth versus Birmingham and a few arbitrary Texas rulings. He stumbles when pressed for appropriate context, then accuses the court of violating his rights. Without any substance, it's a sovereign best hits compilation. Fairy tales are not acceptable to the judge, who demands evidence. This isn't chess in a courtroom. Roosevelt lost the rules to a game of checkers. You've already lost when your legal strategy is just blah blah blah. Subscribe to the channel, like the video, and we'll see you in the next one.
That particular chapter of the United States Code, it would not control what happens in terms of the Michigan legislature defining in Chapter 257 what a motor vehicle is, and an automobile under Michigan law is a motor vehicle. But okay, continue.
Right, a motor vehicle, which is described as anything, even by the Michigan compliance statute of 751, which you just stated, is determined as something that's transporting goods, which I'm not transporting goods.
I understand your position, and I can tell you that that position doesn't happen to be legally correct. But go ahead.
So you're basically stating that there's a misinterpretation of what's in black and white?
No, I'm telling you that you have misinterpreted the application of 18 USC 31A6 and 769 F second or Fed second 1344.
Okay, well, I see what
I've heard your argument.
So there will be no further arguments because I see that you're not going to agree to, because like I said, I've given it to you, the cases where they've, like Shapiro v. Thompson, where the U.S. Supreme Court has said that this driver license is not a requirement, that this is, you're trying to convert a right into a privilege, to which is covered by Article 1, Section 8.
I'll ask you this. Is that right, the right to travel?
That is a right to travel, convey, however you want it, by the U.S. Constitution.
What you just told me was that somehow but regardless, am trying to convert a right into a privilege. Now, the question I have for you is, what right has been converted to a privilege?
My right to freely travel unencumbered and unfettered.
I will ask you this. How is your right to travel removed by receiving the citation?
By trying to require me to have a license to operate a automobile, which is my private vehicle.
Okay. All right. Is there anything else you want me to consider?